I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. You may be seated. I now call the scheduled meeting of the Board of Adjustments to order. Our first matter of business, as we do the first meeting of each year, is to elect chair and vice chair for the Board of Adjustments. At this time, the floor is open for nominations for chair.
Okay, I'd like to.
Pull the microphone towards you, please.
Is it coming along?
Yeah.
Am I good?
You're on.
I'd like to nominate Bill Hoffman for chair.
All right. Are there any other nominations?
Are there any other nominations or second?
Sir?
I'll second it.
We have nomination for Bill Huffman for chair. Do we have any other nominations? All right. Then, Mr. Huffman, all in favor say aye.
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 Any opposed? It is your floor, sir.
All right. Can I do it from here, or do I
You can do it from there, and then next time you'll come over here.
come over there? Okay.
What about vice chair?
He's in charge now.
Okay, there
Oh.
you go.
Okay, our next order of business is to have nominations and votes for vice chair. Do we have any nominations?
Yes, Kevin McMahon for vice chair.
I'd like to nominate myself.
Okay.
I'll second Jack's nomination.
Okay.
All right. We have Mr. Higgins has been nominated and seconded. Mr. McCann has been nominated. Does anyone want to second that one? All right. Mr. Higgins' nomination is put forward. All in favor say aye.
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 You're there.
Okay, I'll take it.
It's yours now.
Thanks for jumping in. Okay, I now call the scheduled meeting of the Board of Adjustments to order, as we just did. As you see, I am the chairman.
Speaking to the microphone.
Oh, yes, that's always a problem. As you see, I'm the new chairman.
There you go.
Oh,
Your phone is.
there we go.
I got it.
I'm taking over as the new chairman. Jack Higgins remains as the vice chairman, and we will proceed. I have on my notes Mr. Brody, but who is the new?
George Ritchie.
George Ritchie. Well, Mr. Ritchie from the Planning and Development Office, please describe the function and operation of the Board of Adjustment to our applicants and the audience.
Yes, Mr. Chairman. The Board of Adjustment is a quasi-judicial body established by the Board of County Commissioners under Chapter 62, Article 2, Division 4 of the Brevard County Code. The Board of Adjustment is empowered to hear requests for variances to the zoning code, or zoning regulations, and to the sign regulations in Chapter 62, Article 6, and Article 9 pursuant to Section 62-254, Brevard County Code. Any person or persons jointly or severely aggrieved by any decision of the Board of Adjustment may, within 30 days after the date of the order is signed, apply to a court of competent jurisdiction for appropriate relief. Mr. Chairman, you have 4 variance items, or 5 variance items on your schedule today.
Okay, thank you. I'm going to ask our vice chairman, would you please explain to our applicants and audience the definition of a hardship?
An undue hardship, a variance may be granted when it will not be contrary to the public interest, or where owing special conditions and little enforcement of the provisions of this chapter will result in unnecessary undue hardship. The term undue hardship, a specific legal definition in this context, and essentially means that without the requested variance, the applicant will have no reasonable use of the subject property under existing development regulations. Personal medical reasons shall not be considered as grounds for establishing undue hardship sufficient to qualify an applicant for variance. Economic reasons may be considered only in instances where the landowner cannot yield a reasonable use or a reasonable return under the existing land development regulations. The applicant must answer a variance of hardship worksheet with 6 questions. The Board of Adjustment will discuss these questions today with each applicant as they requested variance.
Thank you, Mr. Higgins. Thank you, Mr. Higgins. I would like to now address our board members, the applicants, and our audience for a moment. The Board of Adjustment, as a quasi-judicial board with members appointed by the Brevard County Board of Commissioners, will utilize Robert's Rules of Order to conduct our meetings. The chair is asking all board members not to ask questions while the applicants are making their presentations. Once the applicants have completed their presentation, we will begin board questioning with the board member who represents the applicant's district. When concluded, the questioning is open to the full board. The chair will recognize each board member as needed. Once all board members have completed their questioning, we will then open it to the audience who will be here to speak concerning the applicant's application. Anyone from the audience wishing to speak will be given the opportunity to address the board, but only once. At the conclusion of public comment, the applicant will be given additional time for rebuttal, as well as to present their final comments. Once completed, no further comment will be heard from the applicant or the public. We will not use a timer for this meeting. Instead, we are asking each speaker to be concise in what they have to say. It is important that you stay on the subject and avoid information that is not relevant. All persons speaking must provide their name and address for the public record. Those wishing not to verbally state their address may ask the clerk at the podium over there for an address card. Please fill it out and return to the clerk. Are there any questions from the board members about the chair procedure?
No.
Are there any questions from the applicants about the board procedures? Are there any questions from the audience about the chair procedures? Yes, ma'am, you're recognized.
You don't want to mention your address, pick it up there and take it over there. Is that correct? Oh, pick it up
Oh,
here.
I'm sorry. It usually sits over there. It's on this side.
If you want to speak, are you supposed to get a card from them, or you just?
It's only if you do not want to state your address. No. Okay, any other questions from anyone? Well, with that, let's start with our first order of business, which is to approve the minutes of our previous meeting in December. From the board, are there any additions or corrections to these minutes?
I make a motion to accept the minutes as they're recorded.
I'll second it.
All in favor?
Aye.
Aye.
Any opposed? Minutes are approved. All right. And I apologize again, your name, sir.
Mr. Chair, if I may, I asked that we take item H4 first, so we can table that and get Mrs. Cronauer out of here. So item H4 is one that will need to be tabled to the February 16th Board of Adjustment meeting, and that's so staff can re-advertise for the correct variance. I apologize to Ms. Cronauer that we did not process the variance request appropriately, and we'll get it back to you at the next at the meeting to advertise the correct variance in this case.
Okay,
Mr. Chairman, I'll make a motion that we table H4 to the next meeting. Mr. Chair?
no, it's okay. don't know what to do. You're the first one I've had.
You can open up the floor for
Sure.
public comment.
Come to the microphone, please, ma'am.
First, I want
Could
to,
you just
Swear in.
state your name?
my
and-
name is Tina Krockenberger. I'm the owner of the home at 3401 Brahman Avenue, along with my husband.
Okay.
My husband could not,
Is-
pardon,
is the
my husband,
microphone
yes, it's on.
Okay.
My husband couldn't be here today
Excuse me.
because he's ill.
I need
I'm
to
sorry.
swear you in.
Yes, sir.
Do you swear and affirm that the evidence you are about to give to this board is the truth?
Yes.
Okay, accept. Thank you. Please, you have the floor.
Thank you. My husband and I submitted permitting almost 2 years ago for a retaining wall along the north side of our property because there's a drainage ditch and our house dropped 7 foot on the side of the property. We had about 3 foot of a fake
Excuse me.
walkway.
You need to get closer.
Sorry.
Or
Okay.
bend the microphone to you. It's
How's
not
that?
coming
Is
in.
that better?
Yes.
Yeah.
Okay, I'm sorry. I'm going to try to make this concise because you all have what I submitted. My hardship request was not processed properly. What we were asking for is a railing on a deck that we put on the side of the house. The main reason we put that retaining wall and deck on the side of the house was to support the foundation because we had purchased the house after inspections, and we purchased the house, we pulled carpet up, we found an inch gap along the whole foundation on the north side of our home. The retaining structure riprap that the original owner put in was not sufficient. It was never permitted. I went back to all the permits for the county, and we came up with a plan with our structural engineer to put in the retaining wall, and it was after the fact. This was all permitted. We went through all the permitting properly with the county. We spoke to 2 or 3 people in zoning and in building on the best way to protect the foundation of the home. So we tied the house into rebar into the deck, and we put a 4-foot or a 4-inch deck on top of that retaining wall area. We brought in over 20 truckloads of dirt to fill in that side yard. It's 100 foot long and 14 foot out. We then wanted to put a railing on that deck to protect anybody that came to our home. So that's why I went to Paul back in November, Paul Bodie, and we went through everything. I met with him 2 or 3 times over a 6-week period. And I'm now being told today, when I arrive, that the variance request wasn't written up properly. Okay?
May I?
And you all want to table it. I have a contract for sale on this house pending approval for this variance.
Let me just
And I'm
stop you there
sorry.
for a second.
I'm very upset.
Legal. Legal question. The advertising, would you explain what the difference was?
So part of the request, and it's up on the screen there, the variance was for the setback of the deck that encroached into the setback. So the variance is for the height with the railing exceeds the 6-foot allowance that we would for a fence or a wall in this case. And it's not about, that you can't hear the variances that we advertised for the wrong variance in this case.
Okay, that's what I wanted, the last part. Now to legal. Do we have options here?
And then,
I think we're discussing your case.
Mr. Huffman, may I ask a question? Did you,
Hang on till we get legal to tell us if we have options here.
okay, I just wanted to know if y'all got the pictures I submitted yesterday, a couple days ago.
I believe we
Yes.
did.
Okay.
Yes.
I think unfortunately, it's going to have to be moved.
We can't
Can
hear
you
you.
hear me? Can you hear me?
Now,
I think unfortunately, and I understand the hardship that delaying, but I think we're going to have to move it so that it is properly notice the actual specific request, unfortunately. I think that's the most appropriate action.
my apologies, ma'am, but
I just have
we're
one last.
constrained by the law.
I understand, but I have one last question, and I'll go over to the zoning department after this if I need to. If I take the railing off the plan request, and we leave the deck the way it is and get the permit finalized, can I sell my house without a railing? Yeah, okay.
It's
So
beyond
it's not
that.
for you?
After this meeting, we can work with Ms. Cronenberger to see if we can do that or not. You know, I don't know if we can, we will, and that's all I can say. Because we need to make sure that the height meets our height restrictions. So after this meeting, if Ms. Cronenberger wants to hang around and she can get with George afterwards and maybe we can come up with a solution that she doesn't have to come back to this board.
Mr. Chairman, is there a variance needed besides the railing?
So the deck is 4 foot 10 inches high, and we wanted to put a 36-inch railing, which would make it a little over.
Which would be 7 feet,
Yes,
yeah. So my question, is there another variance that needs to be approved on this, not counting the railing? Forget the railing for a minute. Because if so, we could approve the variance. Is there a variance for the width? Did I read this right or no?
It's not, there's no variance for the width.
So the only
variance-
variance is for the railing of the fence, is that correct?
The way it's written is a variance for the side setback for an accessory structure. The variance that she would need to apply for is to the fence code, which is in section 62-2109, and that has not been advertised.
Okay, so if she takes away the fence, assuming, and I know she'll get with you on that, there's no other variance that needs to be done other than for the fence itself, correct?
Well, it's a landscape retaining wall of a certain height. So I don't think that the application paperwork adjusts or addresses the actual height of the structure above the ground. We were dealing with how close it was to the property line.
So it's the height
Something
only.
we'll have to get more information on.
So basically, it's the height.
Yes.
So if they-
All I was thinking, Mr. Chairman, is that if there was something else that needed to be approved other than the fence, we could approve that and then table the fence, and then if they take away the fence, then she won't have a need to come back. That's what my thought is.
Well, better,
All right.
question better than that, if she would agree to shorten the fence to 1 foot.
She started with a landscape retaining wall that's above the ground, and now she's added a barrier on top of that wall. So the wall and fence height is a combined effect right now that it's over a 6-foot maximum. If it was allowed as a 6-foot height limitation for a side street, this is up against another roadway. So the issue is this a 4-foot height limitation or a 6-foot height limitation? And then what is that additional height she's requesting for above either one of those two limits? That's why we have to go back and look at the documentation
swale.
over again.
So there's nothing that we could approve, so she doesn't have to come back if you can work out that fence thing.
If she removed the railing that acts like a fence, the retaining wall may still be too high to meet code. So she may still need a variance to that height.
Okay. But none of that was advertised, am I correct? Yeah.
but the original permit was for the retaining wall at that height.
Without it being advertised, we can't do it.
We'll have to pull the building permit to get the height and make sure that it meets code. So my pledge is that we will work with the applicant to try her not to have to come before you, looking at the permit for the retaining wall and any other subsequent documentation to get her on her way. But right now, with the limited information that we have, we just don't know yet. So we can, at your indulgence, we can table this application to the February 16th meeting. If she doesn't need the variances, she can always request to be withdrawn.
Well, you've made my first, not your fault. You all made my first decision rather difficult, but
And it's nobody's
haven't-
fault that's here. The person that did this request is no longer worth the county, so.
do we have a motion to table this till the next meeting?
Can
We
I
do,
ask
sir.
can I ask one more question?
Yes, sir.
I know the question's been asked, but the answer, I just want to get clarity on. The variance request that we're looking at is a setback variance request. That's no longer applicable? We don't have an issue with setback?
Correct.
Thank you.
And was there a certified engineer that made the report out that this was not safe to begin with for their house on their building permit?
I have not been made aware of that. I don't know.
Has anybody been out there to look at this place?
I've asked for people to come out, and no one has offered. We have an engineered drawings that we
I looked.
submitted
Yeah.
when we first did the project a year and a half ago.
We can look through the file to see what was submitted.
Okay.
Mr. Chairman, I make a motion that we table this to the February 16th meeting, understanding that planning and zoning is going to work with her to have to do their best not to have to come back to that meeting.
I
Do we have a
second.
Do we have a second?
George, did you say?
second.
George? So, all in favor, say aye.
Aye.
Gentlemen,
Any
thank you
opposed?
for your time. Thank you.
Okay,
Mr. Chairman,
yes, sir.
if you'll address her and tell her because this is being tabled, we can't take public comment
Oh,
on this.
okay. Because it's being tabled, we can't take any public comment at this time,
Okay.
okay?
We can't on that matter.
If, as long as it's not related to the case.
If it's not,
If it's not related,
be here next time. I don't know what this.
that, I just, take it up with, yeah.
Wow.
Don't wander off, we need another,
Aye.
number two. All right,
Mr. Ritchie,
Richie, is that?
No, Yardley's the next.
stepping out, are you going to do it?
No, Yardley's.
Mr. Ball.
Ready for the next one?
Yeah, what,
Okay, item H1, Carol A. Hall Life Estate requests variances from Chapter 62, Article 6, Brevard County Code as follows. Number 1, Section 62-1405B, 5B, to permit a variance to allow an accessory structure to be located forward of the front building line of the principal structure. Number 2, Section 62-1401-5B, to permit a variance to allow for an accessory structure to be located forward of the front building line of a principal structure. Number 3 is Section 62-1401-5B, to permit a variance to allow for an accessory structure to be located forward of the front building line of a principal structure. Number 4 is 62-1401-5B, to permit a variance to allow an accessory structure to be located forward of the front building line of a principal structure. Number 5 is Section 62-2100-5-1D, to permit a variance of 492 square feet over the 600 square feet allowed for an accessory structure. Number 6 is Section 62-2100.51D, to permit a variance of 13 square feet over the 600 square feet allowed for accessory structure. Number 7 is Section 62-2100.51B, to permit a variance of 1,498 square feet over the total floor area of a principal structure allowed for all detached structures in a RRMH1 rural residential mobile home zoning classification. The property is 1.94 acres located on the north side of Brockett Road, approximately 1,706 feet west of Hammock Road. Tax account is 21-10383, located in District 1.
The applicant has already stepped forward to the
Mr.
podium.
Chairman, Tom Yardley.
All right.
My office is at Thomas H. Yardley. I'm at 1970 Michigan Avenue, Building D, Cocoa, Florida. I'm here on behalf of Ms. Hall, and we've filed sworn statements. Ms. Hall, the petitioner,
I
has
need to
filed.
swear you in.
Yeah, but I'm not testifying under oath. I'm not giving you an oath. I'm not here as a witness. I'm here as an advocate. Ms. Paul, we've
Yes,
submitted.
but you're representing the applicant.
I'll affirm.
Do you swear and affirm that the evidence you're about, statement you're about to give this Board of Adjustment is the truth?
Yes, sir. I'm not taking issue with
Thank
you,
you.
but I don't think a lawyer has to take an oath. But of course I will.
Robert Rules of Order.
So let me tell you my story.
Go ahead.
First we had World War II, then we had Korea. There's this guy, Paul. Paul gets out of the Army, Air Force, not real sure, goes to work in Melbourne for a company called Radiation Inc. Nice name, I like that. That's like 1950, anything can be done. You probably heard of it, it's Harris Corporation now. Marries a woman, Carol Hall. 1990, this couple retire. They moved to Mims. They worked down in Melbourne. They moved to Mims. They buy a lot. They put a mobile home in it. The husband, over the years, comes to Brevard County, makes an application to Brevard County to make certain improvements to his property. Gets a pad for his mobile home, gets a garage, gets a pump house. Everything is done appropriately and by the book. The mobile home they bought, with all their savings, was only insurable for 30 years. So Mr. Hall dies after he's done all this. They've got the mobile home. He dies. His wife's in the house. She tries to renew her insurance. She can't because she gets a letter from the state that the insurer of last resort says your home is not insurable because it's too old. Then, in 2017, Hurricane Irma hits Mims, rips her roof off, and does 20% damage to the house. She can't get the money to rebuild her house because her husband's died, she's in her 80s, she's got no income other than her Social Security, she's got this house, she can't get insurance, so she lives in this house with no roof. The auxiliary structures are fine. The shed that her husband built, strong as a rock. Turns out there's a program that FEMA has funded for the state of Florida that takes people in a situation like this that have a mobile home that's been partially destroyed, and they will give you a brand new mobile home up to code, meeting all the requirements and everything. Well, long story short, she's approved in 2019. She spent 2 years in a house with no roof. In 2019, she gets approved by this company where they've set up to remove her trailer, take it to the scrapyard, drop a brand new trailer right on her property. Good to go. You got an 87-year-old woman with a roof over her head, finally. And that's when she ran afoul of the code board, because the structures that her husband had built before are now out of code because you're not allowed to have these kind of structures or pads or whatever they are. She's told by the county that she has to demolish them. Well, she's 87 years old. She can't demolish the structures. This group sends out an engineer. The engineer looks to see if they can demolish the structures as part of the funding for the program. The engineer reports back to these guys. He says, their structure's fine. The sheds survived the hurricane. It's the mobile home that needs to go. And because the distance that they're from the house, they're not qualified under the federal program, because the guy's like, we don't have money from the government to tear down a perfectly good shed. There's nothing wrong with that shed or the pump house. And so that's why we're here. Now, whether or not I have a legal position, whereas, she shouldn't be here. She shouldn't have to do this. Everything was permitted. And she's a victim of misfortune, that the only way she can get the roof repaired on her mobile home is to have a brand-new one dropped in. So that's my story. That's why we're here. That's why you should all vote unanimously to approve this situation. The only thing holding this woman back is rules are rules. You gotta, no. But everything she's established, I think she's established. I got this legal opinion where I don't have to apply that you should give it to me anyway. We've established a hardship. We've clearly, if you look at the affidavit that she gave you, that detailed all of the steps that said, how this is a hardship for, she didn't have the money to demolish the structures. The structures are not inconsistent with the neighborhood. She's one of the better homes in the neighborhood, even though she's got no roof. She's kept the lot maintained. There's a house out on the highway that's a freaking junkyard. But it's MIMS. What are we going to do? So I guess you should shut me down and say, if you have questions, everything's detailed in her hardship worksheet. She swore all that. I mean, I'm a little uncomfortable telling you about conversations I got fifth hand that I don't have personal knowledge of. But everything necessary to substantiate this is in her written filings. Mr. Chairman?
All right, thank
Questions?
you. Thank you for that. Guys just jumped up on me. Who's in District 1?
Me.
Okay, Jack, you have the floor for questions.
Well, the comment was made there was permits for everything, correct?
Yes, sir.
Is that true?
They don't know because we
Excuse me.
destroy the rules, the
Excuse me,
files.
sir.
Yes,
Excuse
sir.
me. You don't know?
Our permits only go back 10 years. We
Well-
went back and looked at the aerials and those structures
I
were
have
on there.
pictures, and I certainly don't believe they all had permits.
Oh, yes, sir. We
But-
have a list of the permits.
Okay.
The problem is that we have the numbers, but all of
Okay.
the files are destroyed. But the guy
Okay.
he was a rule-following technician
All right.
at Harris Corporation. So
I've got
they
it.
said, go down and fill out a permit. He went down and filled out a permit. We have like 9 numbers. There's some structures he had permits for that we can't find.
I got it. All right. In regards to the property, you are correct. It's almost the cleanest one on the street. It's well taken care of. I see that. It is a good setback in there. It sets way back in there, so I do have pictures of it, but one thing I resent is your comment on MIMS. That shouldn't have been said the way you said it. Well, it's MIMS.
Sir, I've been here 30 years.
So I lived there, so, but any case, I don't really see a problem if it's gone back there and things are permanent. I couldn't get back deep into the property, I can only get to the front of it, and
Long, thin lot.
it is, but it is very well maintained. That's the best I can say to the other members.
Okay. Are there any other members with questions?
No, I don't have questions, just comment. I read this thing carefully, and I certainly support leaving the structures as they are and dropping the new mobile home, and let's forget about it. That's it.
I mean, I'm here because the legal aid office gave her to me. It infuriates me that it's been 2017. This woman lost her roof in 2017. This is like some third world nonsense. We could be in Haiti. 2017, the woman hadn't had a roof over her head.
She was on that strip where it went straight east to west there. I know, I've seen it. So,
It's a,
anyway. All right.
Do we have any other questions from the board?
Anybody
Last
from the audience?
comments?
From the audience?
If you hadn't
I'm
put
so-
me on oath, I would take back all my mean things about MIMS.
Excuse me. Step aside, see if we have anyone who, is there anyone who wants to speak in
Opposition.
favor of this
For opposition.
or opposition? Seeing none, please come back up. Any last comments?
I'm hoping you can approve this variance and be rid of me.
Okay.
It's your final comment?
Sir?
That's your final comments, and he's asking.
Yes, sir.
Yeah,
Okay.
okay, thank you.
All
Let me
right.
have a seat. Sorry.
Being the case? All right, being that case, I'd like to make a motion that we go ahead and proceed and let them have their new mobile home, and we accept it as stated.
Do we have a second?
I second. Approving all the variances as they're
depicted in the
depicted on
statement.
on the statement and the survey.
Okay, we have a motion and a second. Is there any further discussion from the board? Hearing none, I believe we move to a vote. All in favor, say aye.
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 Any opposed? It's approved.
Stock the time now.
No, we're done. We're done.
Excuse
The
me.
case is done.
How helpful your staff was to me,
Uh,
and that they were a pleasure to work with.
You're out of order.
Excuse
Yes.
me. We did have a written correspondence that I believe needs to be read into the record.
I'm sorry, we don't have to read those in any longer. We took care of that last year.
I have an outdated.
We just have to make sure that everyone that is on this board and anyone speaking has seen that, but we no longer have to read them into the record.
Okay,
Each
just
one
making
statement?
sure.
Each one?
Do we
But,
need to go back and read the six
He was,
questions?
well, no, because we've already voted. He was supposed to read the 6 points, though, on each of these. Am I correct?
Yes.
Yeah, okay.
Do we have a motion to waive that for this?
No, we don't have it. We've already approved it.
It's already done.
All right. Mr. Ball, may we
Okay.
have the next applicant, please?
Item H2 is Lancey Bondasak requests a variance from Chapter 62, Article 6, Brevard County Code, Section 62, 1334, 4, to permit a variance of 1.42 acres from the required 2.5 acre minimum lot size in an AUL agricultural residential zoning classification. Currently in a GU, general use zoning classification, the property is 1.08 acres located on the south side of Angelica Street, approximately 700 feet east of Allen Shepherd Avenue. Tax account number is 2403955, located in District 1.
Okay. Will the applicant please step to the podium? Make sure the microphone's on. Please state your name and address for the record.
My name is Lance Bonsick. My home is located at 3375 Angelica Street, Cocoa, Florida.
Right hand. Do you swear and affirm that the evidence you are about to give this Board of Adjustment is the truth?
I do.
Okay, thank you. How can we help you?
Currently, what I'm wanting to do is do the variance for the property to get to the appropriate size, so where I can put a steel garage for my home. Currently, don't have any structure that can protect our vehicles, one, weather, but two, just in general, to park our vehicles. So in order to do that, that's what I'm trying to do, is accommodate the requirements needed to get my facility, or get my acreage up to the appropriate size so I can have a steel building.
Okay. You're in District 1. Again, Mr. Higgins?
I went by there. The survey here, I guess you turned into, doesn't show the existing sheds that you have there. Is that a dog pen to the far left?
No, chicken coop.
Chicken coop?
Yes, sir.
And then the two in front of that?
There's just two sheds, yeah, for storage.
Okay. And where is the proposed building going to go, to the right?
It would have been, or excuse me, it will be to the right there of the chicken coop.
Oh, to the right of the chicken coop?
Yes, sir. Yep. So it'll be behind the house there in the, I guess that would be the southeast corner in that location.
Is it marsh back there, the land?
No, sir. No. No. There's.
To the west of you, it looked like it was, no?
That's one of the dry slots out there.
Okay.
So, no, sir.
All right. I don't have any other questions. How big a building was it, by the way?
It'll be a 30 by 40, so basically a 3-car. The goal is to get rid of
the house.
The two sheds. So that
How many square feet is the house?
1,600. So it's 1,200 for the building size.
Okay. No more questions?
Okay.
Yep.
Thank you. Are there any other questions from?
I think I'm trying to clarify. The only thing that we're doing here is to give a variance for the lot size so that he can go ahead and get approved for rezoning. That's it.
Misunderstood.
I'm okay with it, that's fine.
Any others? Okay. I think you step back or aside. Oh, wait, do you have any?
No, sir.
Step aside. Obviously, I'm new at this. Are there anyone in the audience who wishes to speak in favor or opposition to this variance request? Seeing none, please step back to the, and do you have any final comments?
I do not.
Okay, thank you very much.
Thank you.
I will make a motion that we accept the request as stated per his request.
Do we
I
have-
second.
We have a second.
Mr. Chair, before you got to read the hardship.
Yep.
Would you help me with that?
I think he's good at that.
Would you help me with?
The 6 questions. That's going to be your job.
Still want me to do that?
Yeah,
I'm
I'm
supposed
a
to.
little
it's actually
disorganized at this point.
I believe it's got to come from you.
Okay. Let's see. So there are
Does it
6.
matter who reads it?
It's fine. I'll take it. We'll figure that out later. There are 6 items that define a hardship, and they were read at the beginning of our meeting, but I'll go through them again now. Number 1, that special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification. I don't believe this constitutes a special condition that's not applicable to other lands in the zoning classification. That the special conditions and circumstances do not result from the actions of the applicant. Actually, they do. By trying to permit a large building on a less than full-size lot. That granting the variance requested will not confer on the applicant any special privilege that is denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. It does in the sense that this is a variance to the standard codes. That literal enforcement of the provisions of this chapter will deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter and will constitute unnecessary and undue hardship on the applicant. I don't believe that the literal enforcement would deprive you of rights other than that you want a building size that's larger than it's currently allowed. That the variance granted is a minimum variance that will make possible reasonable use of the land, building, or structure. Yes, this is the minimum variance that we can allow. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. And no, I don't believe that it's out of harmony or injurious to other properties in the area. No, we did that. We have a motion and a second. Are there any further discussions from the board? Then I call the vote. All in favor, say aye.
Aye.
Any opposed? Your variance passes. Mr. Ball, can we have the next?
Thank you. Item H3, Jeanette L. Knight requests a variances from Chapter 62, Article 6, Brevard County Code as follows. Number 1, Section 62, 1341-5A to permit a variance of 13 feet from the required 20 feet rear setback for a principal structure. Number 2 is Section 62-1341-5A to permit a variance of 2.1 feet from the required 7.5-foot side setback for principal structure. Number 3, section 62, 1341-5B, to permit a variance of 7 feet from the required 7.5-foot side setback for an accessory structure in RU 1-9 single-family residential zoning classification. The property is .17 acres located on the south side of Needle Boulevard, approximately 453 feet east of 4th Place. Tax account number is 241913, located in District 2.
Okay. Will the applicant please come to the microphone? Would you state your name and address for the record?
My name is Jeanette Knight. My address is 315 Needle Boulevard. I'm not living there right now. I'm renting a place. I had a house fire, so I'm renting a place. Do you need that address?
Do we need a, yes.
I get my mail still at 315 Needle Boulevard, Merritt Island, 32953.
Okay. Would you raise your right hand, please?
Yes, sir.
Do you swear and affirm that the evidence you are about to give this Board of Adjustment is the truth?
Yes, I do.
Okay. How may we help you?
I'm asking for this variance. I had a house fire on October 3rd. I'm trying to rebuild on the same footprint that it is, the same pad. I just want to rebuild the house so I can move back over there.
Okay. You are in District 2, and that is, Kevin?
I'm sorry.
That's okay. My heart breaks for you. I went by your property to take a look, and it's very sad, and
Thank you.
sad for what you went through. You're just putting a house back where a house existed and not changing the footprint, and I support that request, and just let the record show.
Thank you.
Do we have any questions from other members of the board? Okay.
I'm so sorry for
No, you're fine. Procedural. Would you just step away
Yes,
from
sir.
the microphone a minute?
Yes, sir.
Is there anyone in the audience who wants to speak in favor or opposition to this variance request? Seeing none, may return. And do you have any final comments?
Yeah, I just want to build and move back over there.
Okay, well, thank you. Take a seat.
Thank you. Thank you for your time.
Okay. Do we have a motion?
I'd like to make a motion that we approve the 3 variance requests as stated in the application and depicted on the survey.
I'll make a second.
Okay.
6 questions.
Any just 6 questions? Not my favorite part.
Nope,
As you know.
not mine.
Okay, I have to read through these 6 definitions of a hardship. The special conditions and circumstances exist which are not applicable to other lands, structures, or buildings in the applicable zoning classification. Under your previous zoning, it was allowed. Current zoning, it's not. But I don't believe that that gives you special conditions or circumstances, since you're not really changing historically what was already there. That the special conditions and circumstances do not result from the actions of the applicant. Our heartfelt condolences for your loss in the fire, and that was not your action. That granting the variance requested will not confer on the applicant a special privilege that is not denied by the provisions of this chapter to other lands, buildings, or structures in the identical zoning classification. Considering the change in zoning, I don't see that provide you with any special privilege. You're simply subject to the change in zoning. Literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant. You're putting it back in the same footprint. and therefore I don't see that you are, that a literal enforcement would be in the general public interest. That the variance granted is the minimum variance that will make possible the reasonable use of the land, building, and structure. We understand you're putting it back in the exact same footprint, so it is the minimum variance. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Again, you're putting it back in the original condition, which was already there, so it is in the general intent and purpose of the chapter. You're not exceeding, well, or you wouldn't be injurious to the area involved since you're simply replacing what was already there. Okay, now, do we go to question?
Vote.
Okay. So I call the vote. All in favor? Say
Aye.
Any opposed? Your variance is approved.
Good luck.
Yes. Mr. Ball?
Item H5, Brad A. Lang requests a variance from Chapter 62, Article 6, Brevard County Code, Section 62, 1371, 4B, to permit a variance of 25 feet from the required 75 feet lot width in BU1 General Retail Commercial and RU-2-30 High Density Multifamily Residential Zoning Classification. The property is 2 acres located on the east side of North Courtney Parkway, approximately 1,085 feet south of Chase Hammock Road. Tax account number is 2318704, located in District 2.
Would the applicant please approach the microphone?
Hello,
All right, could you state your name and address for the record?
Brad Lang, 4910 North Courtney Parkway, Merritt Island, Florida.
Okay. Yes, raise your hand. Do you affirm and swear, do you swear and affirm that the evidence you are about to give to this Board of Adjustment is the truth?
I do.
Okay. How may we help you?
I just want to be kind of like grandfathered in, if there is such a thing. 25 feet off of the required 75 foot. Sorry. Usually I don't have a problem with
You
people
may have
hearing
to
me.
bend it up. You're a little
How's
taller.
that? Is that okay?
Just lean in towards it, yeah.
Okay, so anyway, 25 feet off of 75 feet, I have 200 foot of frontage. You guys probably got the folder right there in front of you, right? Okay. It's been that way since 1964. We have a driveway down the side, goes to 3 separate single family structures behind. I put a state fence up there about 20 years ago, and it's just a driveway. And we're looking to sell off the commercial BU1 zone, which is the front 3/4 acre. That's the purpose.
Okay. You are in District 2, and we're back to, I'm sorry? Back to Mr. McCann again?
Yep.
I went up to the property and took a look. Is this on it? I went up to the property and took a look. Just for some clarification on your application, currently you have one parcel right now, but you want to do a parcel split. And with the parcel split, you're going to zone the front commercial or business, BU2?
It's already zoned BU1.
BU1, okay. And the rear is zoned residential?
The rear is currently RU-230.
Okay. The, it was, did you, I didn't notice the variance notice posted. Did I just miss it? I mean, can you confirm
yeah,
it was posted?
one of the kids grabbed it. It was on the corner up there by the garbage cans.
Okay.
Yeah.
And then the,
I saw it posted. I live there.
I'm not doubting, I'm sure the county did it. I just,
Yeah.
I missed it, and I just wanted to make sure it was.
They have 6 kids at one house. It's kind of
The driveway right now goes east and west along the fence line, the south side of the
Correct.
property.
yes, correct.
Right at the moment, to enter the business location,
Yes.
people would have to turn in, go basically over the driveway to get into the business location.
If we left that entrance open, correct.
And you'll plan on
We can-
reconfiguring that?
Yeah, when the new business comes in, he'll have to do all that.
All right, I don't have any other questions.
Mr. Chairman?
Yes, sir.
You're requesting 25 feet from the 75 feet. However, you could do 15 feet and take it to 60 instead of 50.
Buyer doesn't like that.
I'm sorry?
I would rather not do that. That's the reason I'm here. It's basically, the problem is the existing commercial building, the way it sits. If you take any more off on that side, he's not going to have any access along the south side of the building.
Okay. But my understanding is you're wanting the 25 so you can split it, correct?
Yeah, actually in 1964 it was already split, but the records aren't back that far. When I bought it in '02, I originally had a sales contract on just the front building by itself. They were going ahead and doing that, but I have parcel A and parcel B on a warranty deed on the back of it, and it describes both of those lots. 1964 though, so.
Okay. But 60 foot would allow you to split it, giving you a 15-foot variance instead of a 25-foot. Is that correct?
The way it's too much off of that side of the business for the business to do it. I'll have to leave it all one property if I don't have the 25.
Okay.
This question is for the zoning. Whosoever put this together has some knowledge that we're unaware of that suggested that this is not the minimum variance that can be requested, and suggested that maybe we should consider 15 feet. Could you tell us?
That's what I was.
I understand, but I need to hear from you guys.
Sure. So based on our calculations, the setback to the existing building and where the 50 feet is roughly 28, 27 feet. And so the side setback for BU1 is 10 feet, I believe. And so with the 60 feet would allow him to have sufficient width for that stem. So I understand that the rear property already is developed, but if somewhere down the future that they decide to develop, 50 feet gets a little bit tight of where they have to do the driveway, stormwater, and all the other infrastructure improvements that go into that. So it's not just sticking a driveway in there that you have to be concerned with. And so when we looked at it, we were looking at, 60 feet would be sufficient and still meet setbacks.
And that 60 feet would be to the commercial portion.
No, the 60 feet would be the stem for the multifamily to the back.
I got it, okay.
Can I say something for a second? Beside the commercial building, if you take 10 more feet off, it's going to leave 17 foot 5 inches for this business to have his business up the front. That's all he's got on one side of the building. It's 17 and a half feet. That's from here to there. Just saying, it's encroaching on any saleability. They want to put a restaurant up there if it matters. So. And we need one on North Merritt Island.
Okay. Any other questions or discussions from the board? Could you
Certainly.
step aside, please? And is there anyone in the audience who wants to speak in favor or against? Sir, may you approach the microphone, please? I have to swear you in before you speak.
Okay.
So please state your name and address for the record.
I'm Robert V. Scora, and I live at 4950 Ralph's Lane. I didn't really know what was
Hang
happening
on.
today, so
Now I need to swear you in. Do you swear and affirm that the evidence you are about to give to this Board of Adjustment is the truth?
yes,
Okay. Are you speaking in favor or opposition?
I'm speaking in opposition. At least I believe I am.
Opposition, okay. Please proceed.
The gentleman here that was asking for the variance, I think he'll pretty well back up what I say, but the property behind it is Ralph's Lane. Okay, Ralph's Lane is owned by me. I own the house at 4950, and I own the road that goes back. The only drainage behind him is Ralph's Lane. So I'm responsible for maintaining a ditch. Because all the building we've had recently in Harvey's Groves and everything else, water from his property drains to the back. And it now goes in my garage. So there was originally variance there. In the beginning, they built a restaurant, and it was a bar, and everybody approved it. But I don't want to see anything else built there or somebody else take over another restaurant where I get more water, because it'll leave my house unusable. If they want to buy my house in the road, I'll gladly sell it to them, and they can build whatever they want to. But I just can't afford to be doing anymore. I'm over 80 and a disabled veteran. I can't maintain things for somebody else. So that's all I have to say, and I thank you. And I think this gentleman knows where I am, and I think he knows the situation there.
Okay.
So if he,
Would you hold just a second there? Any of the board members have questions for this, what would you call him?
I mean, I have
Okay.
pictures, if they ever needed them, I can show them where the water goes, because I did take pictures where the water almost got to the restaurant.
Yes,
and
I have
his
a-
other
I have a
buildings
question.
were to the back.
My question to you is, how does him getting a variance for
It was,
for 25 feet just to cut the, to cut the property?
that wouldn't affect me at all.
That wouldn't affect you at all?
That part wouldn't, but if it's built for a restaurant that they're going to be enlarging, I'm already getting the water from the
Well,
front.
here, we're not here to talk about what he can or can't build there. All we're looking at is to say is approve his 25 feet so that he can split the lot, cut
Right.
it off. That is it.
If he splits the lot
Mm-hmm.
and sells the front, they have to have a road down it, correct? Or it's a driveway for the other property. You have to have an easement to get to that property.
That already exists.
It's a separate driveway already? It's zoned as that?
Can I jump in for a second?
Yeah, please, Mr. Ball.
I know this is outside the purview of you guys, so I'll take this opportunity to do some education here.
Thank you.
So if Mr. Lang, just sells the, property off, no improvements, we wouldn't require anything. However, if there's any improvements that are done to the front building or to the rear of the property, then I'll have to bring it up to code, whether that is a paved driveway, stormwater, these properties are very old that were developed prior to us having stormwater requirements, but any redevelopment or new development on that property would have to be brought up in the code, which would have stormwater attenuation requirements that may or may not help with the existing drainage problems.
Thank you. So essentially what we may or may not approve here will not necessarily affect you in the future until they decide what they're going to do with the front
Yes,
property.
that's
And
what
when
I'm worried
and
about.
what I'm understanding is, before they make any improvements, they've got to go through the approval process and a whole host of other zoning requirements before something can take place.
Yes.
Right now, we just want to give him yes or no on whether he can
Well,
get
I
his.
agreed with him when they wanted the variance for the restaurant and the bar, because I didn't think that would affect me, because we knew what size it was and everything.
Okay.
But this, if they do anything else there, it's already almost made my garage unusable.
Okay, rest assured, though, that what I've been told just now is that if more improvements has to be made, then they've got to do everything up to code, including the drainage and so forth.
Doesn't the lot size have something to do with this? Back there, if he wants to sell the front off from the back, it was all one lot before with the business.
And we're just saying that, yes, he can go to whoever will grant him the ability to cut it off.
That'll be a smaller lot then.
Mhm.
Okay, then I guess I lost. Well, thank you.
Future development will meet future permit requirements.
They've told me that with the past few places that have been built along there, that I wouldn't get any more water. They can look at what I got. I mean, there's got to be a way to take care of this, because I have a drainage canal in the back, which is the lowest. You can't make water run uphill, but that's what they're trying to do here. And the county keeps promising me it won't happen, but all they have to do is look at it.
Okay. At this point, all we can do is vote on the variance. Any future construction,
I don't
it goes
wa-
back to the permitting
I don't
board.
want to make it rougher on this gentleman. I'd like to see him keep it.
Okay, thank you.
Can I be on the record?
Not yet.
Not yet.
Okay. When I have a chance.
Are there any other audience members who want to speak in favor or opposition? Seeing none, shoot, what's our next?
Now he can come back and make his final comment.
Now you can come back and make it.
On the record for this gentleman that I have the worst, I have the same type of problem as he does, and it came from Egret's Landing. The new development raised the whole neighborhood 3 feet and dumped it all into island lakes.
Okay.
Sorry, I'm talking, sir. Island lakes and all the way down. Even the karate guy next to me has said the same thing. He has a lake behind him. It was never there. So what they did, and I was on I've already discussed with the St. John's River Management, the wastewater, I've discussed it with them, and it's just a matter of a lawsuit now because of a subdivision. So anyway, I'm just making a statement. I have it as bad as you do.
No, we're done. Each applicant one.
I think you all need to know what's really happening.
Sir, we're done, we're done. So we, make a motion?
No, you finished with his final?
Yeah, you're finished with your comments, correct?
Yes, sir. Yeah,
Okay.
sorry. I just wanted to respond to it.
All right, I have to read the, is that next? All right,
Hey, guys.
little order in the room, please. Okay. All right, I'll read the 6 definitions of a hardship and how they apply.
I'm sorry, sir. My fault. You asked me. My apologies. Need to see if there's any motions first.
I thought we had a
Then
motion.
do the 6. We haven't had a motion.
Okay. Is there a motion to, for this applicant from
wanna do so?
board members?
Are we still in the discussion stages? Are they
No,
closed?
where's the motion?
I-
Motion and then discussion.
All right, I make a motion to approve the variance request as stated in the application and depicted on the survey.
Do we have a second?
I'll second.
Okay, we have a motion and a second.
I would like to make an amendment if I could.
We have a request for an amendment.
I'd like to amend. Let me get this right. My light doesn't come on, so I don't know when it's on. Mr. McCann, I'd like to amend, if approved, that we approve the variance with the suggestion of 15 feet from the 75 feet lot width instead of 25 feet.
So we have a request for an amendment. Do we have a second for that?
Hold on a second. I think we should deal with the first motion first.
This is an amendment to
no,
the
this is
motion, so we
amendment
don't
to
have
the-
to.
We got a first and a second as
Yes, sir.
depicted in the survey.
Yes.
Open discussion.
And then we are allowed to amend.
Well, we can,
The motion.
we can say no on that one, and then,
That's not how it's done, sir.
Well, I don't think it is.
There's a
Attorneys?
I really think that George is right.
legal.
I believe as long as, that just can't, we can cancel it out.
You can, Okay, so we have a motion that's been seconded and then a motion to amend that has not been seconded, but that.
No, he just seconded it.
Okay, then you're proceeding on an amended motion, is my
Okay. That is
understanding at this
correct.
point. Now you can
Now, can we clarify what
vote
that
against it and
amended
start
motion
again,
is?
but you have to
amended
finish this.
The original motion was to allow 25 feet from the required 75-foot lot width. The amended motion would be to have 15 feet from the 75-foot lot width, which is what the minimum requirement would be in order to separate the land.
Now, my understanding is that we discuss and then vote on whether to attach the amendment
That is
before
correct.
we go back to the original motion.
That is correct, sir.
Okay, so we have on the amended motion, or on the amendment to the motion,
We would vote
we
on
have
that now.
any
already had a second,
any
so it's a
discussion on that amendment? Just the amendment part?
I've considered an amendment, that's why I addressed it. And the gentleman, based on his comments up here, convinced me that maybe we need to stay at the 25 feet rather than the 15 feet. That's why I second the motion to approve as depicted.
Okay, any other discussion on whether to accept the amendment to the original motion? Here, go ahead, Kevin, if you want to say.
I just want to state that looking at the survey and going up to the property is basically creating a flag lot. And the residences in the back, it doesn't change anything on their main portion of the property other than the access, the ingress and egress of that flag lot. And that's where his variance is to make it 50 feet wide as opposed to the amendment, which would be a 60-foot wide.
Okay,
It'd be a wider driveway area.
Yes.
Yep. That's what,
Which would be more beneficial.
I don't, the driveway's already pre-existing. I don't think you need a 60-foot wide driveway.
But we do discuss what is the minimum requirement needed to do what he's wanting to do, and that is the minimum requirement, so that's why I'm bringing it up.
No.
Okay.
so any other discussion? Okay, this vote is on whether to accept the amendment to the original motion. Is that correct, Leo? Is that
That
what
is
we're doing?
correct,
Okay. So, all in favor of the amendment, to attach the amendment to the original motion, say aye.
Aye.
Any opposed?
No.
No?
When you say aye, do you mean?
I oppose.
No, you oppose. Kevin, do you oppose?
Opposed.
Okay. I also oppose based on
Okay.
what Mr. Ball had explained to us. So now we're back to the original motion, which is 25 feet, correct?
Do the 6 points and then we vote on it.
Okay. All right. So now we do I read these, the definition of the hardship, 6 points. The special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification. I don't believe these are, there are special circumstances here, but I don't believe that they're substantial. The special conditions and circumstances do not result from the actions of the applicant. They do not result from the actions of the applicant since it basically confirms existing conditions. The granting the variance requested will not confer on the applicant any special privilege as denied by the provisions of the chapter to other lands, buildings, or structures in the identical zoning classifications. Again, I don't believe that granting it will confer any special privilege. That literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in the identical zoning classification under the provisions of this chapter and will constitute unnecessary and undue hardship on the applicant. I did hear some back and forth about, I deprive the applicants of rights. It seemed to be a preference rather than a absolute need. That the variance granted is the minimum variance that will make possible the reasonable use of land, building, or structure. I believe we've discussed that through and consider this the minimum. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Granting the variance will not be injurious, but future development needs to fit the permitting and zoning and drainage codes that exist in that area. What's next? Okay. Any discussion on the original 25-foot motion? Anyone? Okay. Seeing no further discussion, I will call the vote. And all those in favor of the 25-foot variance, say aye.
Aye.
All opposed?
Nay.
3-2, I believe. 3 ayes, 2 nays. Your variance passes.
That's it.
Having no further business before the board, I declare the meeting adjourned.
Good job, sir.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any